I see you both there. Excellent. All right, to remind you all, 20 minutes aside. Ms. Norse, how much time would you wish to save any time for rebuttal, ma'am?
5 minutes, please, Your Honor.
Very good. All right, and whenever you're ready, please proceed.
Thank you, Your Honors. May it please the court, my name is Kristen Norris, and along with Stuart Markman of Kynes, Markman, and Fellman, we represent the BioSpine entities. This is a certiorari proceeding to review an order that requires a healthcare provider who is not a party to the underlying litigation to produce privileged trade secret information to the defendant and its liability insurer, State Farm. The trial court departed from the essential requirements of the law in two separate ways. First, it compelled disclosure of trade secrets without applying the balancing test that Florida law requires. That is, it ordered disclosure without first making findings that State Farm had demonstrated a need for the specific discovery that outweighed BioSpine's privacy interests. And second, the trial court did not order that the privileged information be kept confidential. Both errors are a departure from the essential requirements of law that require reversal here. The basic principles that govern this proceeding are really not contested. State Farm doesn't dispute that the discovery it is seeking is trade secret information. It includes details about BioSpine's overhead costs, its internal pricing methodologies, and then the amount that it collects under different contractual arrangements. And under section 90.506, BioSpine has a privilege to refuse to disclose the information. And State Farm's response concedes that in order to defeat that privilege, it had to show the discovery was not only relevant, but necessary, and that its need outweighed BioSpine's rights to keep its confidential business information private. Case law is clear that State Farm standard is even heightened in a case like this where you're seeking it from a non-party medical provider like BioSpine in an injury case. BioSpine's motion for protective order explained the balancing test. It noted that the trial court had to make express findings. And despite that, the trial court never applied the balancing test and did not make any findings on necessity. That's the departure from the first departure from the essential requirements of the law.
Ms. Norse, you know what we did in Gulf Coast. Obviously, internal cost structure is a trade secret. We reversed and remanded for the trial court to make those findings. Is that the remedy you're seeking or not?
I am seeking a reversal for the trial court to make the analysis.
Okay, because Judge Thomas made certain statements about, yes, proprietary information is discoverable, but never used the word trade secret, nor did she ever use the term balancing test whatsoever. I can't find it. It's certainly not in the order.
Right. And she never says necessity. I think even if she'd said necessity, oh, this is necessary. And then she never tailors what she's doing to what's necessary, which if you look at the cases where the analysis has actually been applied, the Katzman versus Red Iron cases, the Hassan case, there's a connection between finding the necessity and then tailoring the discovery.
Yeah, because I get this suspicion here that this is a huge issue, but fortunately you have 3 people who litigated it as lawyers and 2 have decided as judges. I'm a little concerned about the implication from the defense that there's not only impropriety, but there may be illegality. That concerns me deeply. And we don't really need your charts to help us out about, overbilling and things like that, because there isn't any evidence in the record that there's overbilling. There's not one affidavit, not one deposition from Blue Cross as to why they denied the majority of the charges. So one question I have for you, Ms. Norse, is this. It's kind of like the analogy of work product. If you can get the substantial equivalent, you're not entitled to work product. I know that's not the rule here. That's not the standard. I'm using it as an analogy. But can't the defense obtain the substantial equivalent in terms of proving that these alleged bills are allegedly unreasonable, too high for the community, and they're not coding them properly without getting your trade secrets?
Yes. And actually, I would say that the availability of other alternate information to make the same point is part of the analysis, even in the trade secret. It's one of the factors that you consider. Can you make the same point that you want to make without getting into overhead costs and how they set their prices and opening up the books here? And I think if you look at the overview of the case law, what you see is, yes, market rates, published reimbursement rates, expert testimony saying, well, there's a range based on that goes from the low end of Medicare and Medicaid up through, multipliers of that. So if their point is to charge, to question the reasonableness, they have access to that information. They're actually an insurer who reimburses this across the state of Florida.
Is there any evidence in the record that demonstrates on behalf of the defense that BioSpine used too many doctors or too many techs to perform this particular injection or procedure? Or is there a coding expert that says BioSpine improperly codes?
Right. There really was no showing. The main thrust of State Farm's argument was, we know that BioSpine charges different charges based on different contractual scenarios. And we want to use that and this other information to try to argue to the jury that their charge in this case was unreasonable. But there was actually not even a showing based on the market rates that this charge seems out of whack. There was not a showing of any impropriety. The Katzman case, the doctor was performing a specific procedure that one insurer had said was not beneficial. So there was no special showing as to even make a sort of a threshold showing that this charge was unusual. I would come back to your Blue Cross Blue Shield point, because I do think that's important to note. They did have this separate theory that the Blue Cross Blue Shield contract might not permit them to submit this bill. We have not contested that. That is still pending before the trial court. They are seeking and have obtained some of the discovery on the Blue Cross Blue Shield contract.
And I understand that, Ms. Norris. I think, as I hear your argument, your main concern is the issue of trade secrets, because when you think about the cases that from our court, golf course, Giacalone, and all of those, dealt more with relevancy. But as I understand your concern, that here, because of the overbreadth of information requested, that really is encroaching on the trade secret on your client. Is that, and I'm trying to summarize in a nutshell, is that your position?
Yes, it is. I think if you look at, and I think it's important to talk about the Giacalone case, right? Because that's really the first case that kind of opens up this discovery, but that's a provider versus patient case.
Well, I was going to say that that's a little different, isn't it? Because in that case, when I have the case right here, the hospital is the one that sued the patient for unpaid bills. So making the question of the hospital's pricing structure, the central question in that case, which is much more relevant and discoverable than here. Am I reading it correctly?
I think you are. And not only that, the only issue in that litigation was the reasonableness of the price.
Correct.
This is, the reasonableness of each individual health provider's medical bill, and whether maybe they charge a little bit less to, or maybe a lot less if they have a contract that demands payment.
Well, but in candor to the defense, Gulf Coast expands it. So there's no doubt Gulf Coast expands it. But I want to know your opinion, and I'm going to ask opposing counsel too. Does Gulf Coast get us there? Because in Gulf Coast, I do believe the provider conceded or made certain concessions, and I think Judge Morris wrote the opinion, and that was kind of a linchpin where, okay, we accept those concessions, therefore they are relevant and discoverable. What you're saying is they aren't discoverable until there's a balancing test, correct?
Correct. And
do we have an opinion like this case yet, where you are objecting? They've got to do they have their burden, and the court has to do the balancing test. Mm-hmm. Do we have one yet?
I'm gonna.
If I may, Ms. Norris, and my understanding of golf course is that that our court, and you're right, Judge Lee, there was Judge Morris, he quashed the order there because the court failed to perform that balancing test or to protect trade secret. But I read golf course that in reading golf course, I thought it supported your position, Ms. Norris, because in golf course, they relied on the Giacalone in concluding that the internal cost structure is relevant to claim of unreasonable charges with respect to a non-party medical provider. True, but relevance isn't the main issue here. I think you mentioned that before, that they're entitled, they may be entitled to that. Your main concern, as I understand it, is the trade secrets, correct? And the trade secrets in golf course it indicated to protect the trade secret because the court had to do the balancing test. Am I reading that correctly?
You are. And so let me try to distill all of this based on the different questions. Number one, I don't think Gulf Coast does get us there for that reason, that Gulf Coast says this might be relevant, but there has to be the necessity established before it's discoverable. And so that's what has to happen here. There has to be some showing. That's the one case where your court has said that maybe internal cost structure is relevant at some level, but you still have to show necessity.
But do you have a case? Do you have a case where the showing is less than evidence? Because so far we only have attorney argument from the other side. That's not evidence.
Correct. And I don't think it's hard to say. I would say that there are a couple cases where the trial court applied the analysis on trade secrets to a non-party provider, healthcare provider, and allowed some tailored discovery of differential pricing. So that's the Hassan case. Trial court applied the analysis, made the necessary findings, and the fourth district found not a departure from the essential requirements of law. And it looks like there was a showing about discriminatory pricing in that case because there's a footnote, but doesn't really say what the showing was. There's the Katzman versus Red Iron case, again, a showing that the doctor was continually performing something that was potentially not medically beneficial. There's the McInnes case out of this court where there's not a lot of discussion, but it looks like the court applied the analysis and this court quashed for lack of confidentiality protections, but said some billing and collection information was discovered, but we don't really know what it was. What we don't have is any case expanding internal cost structures or price setting methodologies or what your overhead cost is for each procedure. We don't have any case expanding the necessity to that. And the few cases that find necessity for differential pricing are tailored. You know, there's the Lake Worth case where they said, okay, 2 instances of a different reimbursement rate. All of which just comes back to how important the trial court's analysis is, how important that initial showing is. And yes, I do think it needs to be based on some kind of showing, at least a proffer of evidence to suggest that this bill or something that the doctor is doing is somehow, you know, justifying then opening up the books. And this is exactly, you know, allowing this kind of discovery. And I think what State Farm's trying to do here is basically take an exception in these cases where a court narrowly applies the trade secret analysis and making it the rule. And now because these cases have allowed some of this discovery, now this is the rule that you can get it. But that is the opposite of what the Florida Supreme Court has held. And the Sykens case was on bias, but in the Worley case, they recognized this could be relevant to unreasonable pricing, but it's not permissible absent compelling and unusual circumstances.
Let me ask you, because it appears that the order as to overhead costs and as to CPT coding does apply to this particular case, but it appears that paragraph 4 concerning, you know, the realization rates, litigation, PIP versus health insurance, patients, plural, this appears to go beyond the Walker case. Am I reading this right?
Beyond the Walker case?
It goes to all their cases, what they've accepted in PIP versus health insurance.
Correct.
Why is this admissible here in this particular case?
Correct. Yes, it's very broad, and the judge didn't do anything to sort of narrowly tailor it to any specific showing here.
Wouldn't there be potential HIPAA violations too?
I think
to have to produce that?
Right. I think there's a lot of implications. And if you look at sort of the breadth of the case law here, you have HIPAA implications, you have the proprietary information of third parties like the insurance companies. You also have the collateral source rule. How are you going to conduct this cross-examination about whether the insurance paid this and the Medicare would pay this, and then the jury's going to be scratching their head, well, which one applies here? So there's a lot of implications. There's a lot of reasons why you know, this is not something we want the court to delve deeply into as to every medical bill. And I think it's important to note this is one bill of 3 that the same discovery has been presented to. And while this one's a bit larger, although not shown to be out of whack with any market rates, the other 2 are $5,000 bills, and the analysis then would apply to any healthcare provider.
And if I may, Ms. Norris, you're about to get into your rebuttal. If you're welcome to go forward, if you'd like to reserve the rest for rebuttal, I'm happy to do it at this time.
I'm happy to wrap up for now. The trial court's failure to consider, much less make a specific finding of necessity before compelling Biospines to produce its privileged business information
Oops. Ms.
is
Norris?
a departure from the essential requirements of law, as is it clear to ensure confidentiality and the order to be quashed.
Very good. All right, Ms. Norris, I'll save the remaining for rebuttal. Thank you, ma'am. Okay, and if I could have you, great, you've muted yourself. And Mr. Proul, if you could unmute yourself before you start, I just wanted to say that we've noticed that the response brief that was filed in this case appears to attempt to circumvent the page limitations, so the extensive use of single-spaced footnotes. Now, the interest of getting this case resolved, we did not strike the briefing, but I just want to take this opportunity to remind everyone that the appellate rules do apply to everyone. And with that, Mr. Proul, you've got your 20 minutes. We're ready to proceed, okay?
Thank you, Judge. May it please the court, my name is Aaron Proul. I represent the appellees in this court and the defendants below, Robert Martinez, MD, PA, and Robert Christopher Martinez. The original petition had two separate issues that it appears that one of them has now been abandoned in the oral argument. And some of the court's questioning shows some of the confusion by the abandonment of that argument. So it's important to distinguish the procedural issue regarding whether or not the trial court did what it's supposed to do when a party opposing, or a non-party in this case, opposing discovery raises a trade secret defense. And there's some hurdles that the trial court has to go through, has to dot the I's and cross the T's. And so the argument is that that wasn't done in this case. And that is a purely procedural argument. And there are, I believe, two cases in this court, the Gulf Coast case, I can't remember the other one in this, LSI v. Macinast, and then there's the Hassan case in the 4th DCA, which all say this information substantively, this unreasonable pricing discovery, is substantively allowed under Florida law, but they all remanded back down to the trial court to see if it would be allowed in the specific case. In other words, to see if the defense could establish reasonable necessity.
And I think, if I may, Ms. Brown, I think in this case, based on the questioning that I had of Ms. Norris, and I believe Judge Sleet as well, the key factor here is that the request that was made, that was a blanket and overbroad request. And in this case, the trial judge, based on the existing case law, failed to look at the balancing. It's not a question of whether things are relevant or not. We're not discussing the relevancy. I think we're talking about the fact whether or not this is infringing on trade secrets. How do you respond to the fact that the trial court did fail to do that balancing act, to make a determination and to get into all of these issues? Because if you look at what you're requesting, there's some problematic things in this request.
Okay, thank you. First of all, one of the assumptions made by the panel is incorrect, that I have a broad request and that I've requested documents. The only document I've requested is the contract, and that's not an issue in this petition.
Well, and if I may, Mr. Proul, let me do that, because I know you said in your brief that you're just seeking testimony, but if your briefing says that you're only seeking testimony, however, I'm looking at your motion to compel, it repeatedly asks for documents.
The order is just for the testimony. What the confusion comes from the fact that the subpoena ducis tecum that I use has an exhibit A, and it doesn't distinguish at that time. It did not have a separate attachment for exhibit B for areas of inquiry. So I would ask for all of these documents and testimony regarding these documents. In the trial court, I made it very clear that I simply need to be able to ask, What's the overhead cost for various procedures that were done? What is the amount that you recover from other insurance carriers on these same procedures? There are 4 appellate cases that allow that question.
For how
And
long
there
of
are
a period of time?
3 years. Or actually,
The
that
order
one is,
the order doesn't say how long. The order
yeah, you're
is
right.
unlimited.
Right.
Plus, it would apply to anybody else's case.
No, it applies to.
Why shouldn't this be limited? Don't interrupt me. Why shouldn't this be limited to Ms. Walker's case?
Okay, because I have cited 14 cases in my brief that say the defense is not limited to the plaintiff's case. And the other, I'm going to get back, Judge Kuzam, to your original question, but I want to respond to Judge Sleet's concern that the defense is supposed to be limited to hiring an expert.
I didn't say that.
To do differential market pricing. And why do we need to get into the trade secrets was what I thought that you had said during the initial discussion. And the reason for that is answered in this court's Giacalone opinion taken from Colomar. And all of these other cases, the other 13 or 14 cases are all citing Giacalone. In the case in the federal system, they're all citing the Colomar case, which Giacalone relies upon.
Mr.
That-
Poole, but the Giacalone case, and pulling it right here, that's a little different. That's it. You're dealing with a dispute between parties. We're not dealing with that here. And as you know, this is a little bit different. And
Right.
I want to make sure that that is clear in our discussion today.
Yes. And what I want to make clear is what Judge Sleet already said in response to Your Honor the first time you said that. And that is this court, the second district, has already expanded Giacalone to this situation, where instead of it being the patient who is a defendant against a provider's bill, it is the defense in a personal injury case that is now seeking the discovery from a non-party provider. That is this court's Gulf Coast case.
And looking, and as I mentioned before, and looking at the Gulf Coast case, again, we have to look at the facts of that case as well, as opposed to painting a broad brush that applies here. In Gulf Coast, yes, we did quash the order because the court failed to perform that balancing test. But again, in Gulf Coast, it basically dealt with, we talk about the reasonableness. It dealt with the unreasonable charges with respect. Here, a lot of the information are going into trade secrets and protecting trade secrets. So in my mind, I see that there's a distinction in that. And correct me if I'm wrong, and this is the opportunity for you to tell me why am I reading this incorrectly, Mr. Pruitt?
Yes, Judge, you are. The Gulf Coast case deals with Giacalone Category 3, which is trade secrets. That is the internal cost structure. That is a trade secret. And the first argument by the defense, the provider in that case, who was a non-party, just like our case, was exactly what you just said, Judge. It was, hey, second district, don't apply Giacalone to this case because the provider is a non-party. This isn't the patient asking for this discovery. And
well, excuse me, that goes really to the nut of this, right?
Right.
Your client was obligated to prove the reasonableness of the damages claim. Now,
that's the plaintiff's burden.
Right. And
I'm the defense.
And you're the defense. So the plaintiff is obligated to prove the reasonableness. You are trying to prove the unreasonableness. And this is the only way you can do that, because to my understanding, there are a lot of different ways to challenge the reasonableness of a medical bill. Charge master, usual and customary, community, and to State Farm's proprietary information would seem to be the last resort as opposed to what's generally available. So that's what I'm grappling with.
Okay, and that's the same thing Judge Sleet was grappling with. So let me just read from you what this court said about that exact argument. Okay, this court said,
which one are you reading from?
This
Which
is
one
Jacques Alone. This is
Thank
Jacques Alone. The hospital argues that Mr. Jacques Alone has not shown irreparable injury because he has not exhausted other means of obtaining pertinent information, such as comparative market pricing. That's the exact argument you just made, Judge Lebret. That's what Judge Sleet asked Ms. Norse of when she was speaking. This court
But
said,
again, I mean,
this
Jack
court
alone
rejected.
is a direct dispute between the provider and the patient concerning the reasonableness of the charge, as opposed to an exercise to come up with the damages component in a plaintiff's personal injury claim. That's different.
It is different, but if you read my brief, you will see that 14 cases.
I did read your brief, just so you know.
14 cases have said that you take the Jacques-Alone categories, the 3 categories of unreasonable pricing discovery, and you allow the defense to step into the shoes of the plaintiff, because the plaintiff no longer owes that money. That's the money that's the defense is being asked to pay. So this court said the use of comparative market pricing is only one type of relevant information which may be helpful in establishing a claim of unreasonable pricing. And so they disagreed with the argument that Judge Sleet has raised and Judge Lebret has raised here today. This court has already done away with that and said, you are entitled, if you establish reasonable necessity, and this is why I can't emphasize enough the need for this court in rendering its decision to separate the problem, the procedural problem. I'm coming back now to Judge Kuzam's original question. The trial court did not say the defense has established reasonable necessity because of X, Y, Z. It did not do that. And so if this court has a bright line rule similar to like in federal cases, if you don't cite rule 3.01G, the judge doesn't even read your motion. The clerk's office just rejects it. So if this court has something similar where you have central staff saying, did the trial court say there's reasonable necessity and say for X, Y, Z? If that's what this court does, then this case needs to go back down to the trial court. So the trial court can say the defense has established reasonable necessity because of X, Y, Z.
But how have you established reasonable necessity other than your bare allegation that they're overbilling? Because here's why. Ms. Barnett said in a hearing, if I can get that Blue Cross Blue Shield contract, I can take their deposition and find out why they denied the majority of the bills. And if they denied the majority of the bills by saying they're unreasonable, then she argued on behalf of your client that you're not responsible for it either. And I think this whole thing started when Blue Cross Blue Shield denied the majority of these bills for this type of procedure. It was a $39,000 bill or something like that, and they only paid $3,000. So Ms. Barnett was headstrong and full force going into, let me have the Blue Cross Blue Shield contract, and that might just settle this all. But now you're seeking, do you agree or not that what you're seeking from BioSpine is trade secrets or not?
Oh, it is. It's trade secrets.
Okay, then do you agree with me that Judge Thomas in her ruling simply said, this is just a request for access to information. Mr. Daniels said they're not entitled to proprietary business information. Judge Thomas says, yes, they are, if there's a protective order in place. The only place where she put a confidentiality agreement was as to the Blue Cross contract. There's no confidentiality agreement whatsoever as to the overhead costs, the amount charged, realization rates, or the CPT coding. And she didn't do a balancing test whatsoever, nor did she utter the words trade secret. So this should go back, shouldn't it?
Let me just correct one thing. The confidentiality order allows, like all of them, allows Gulf Coast Spine to label anything it wants in all the world as confidential. It's then my burden to go to the court and say it shouldn't be. So the statement made by Gulf Coast Spine that Your Honor just reiterated is a false statement of fact. If you look, and by the way, Gulf Coast Spine did not.
Let me stop you right there, because the order says Blue Cross Blue Shield and Biospine must get together for a confidentiality order. That has nothing to do with Biospine individually. It's Blue Cross and Biospine.
What happened in this case was first of all, that order is now corrected. The order that
Wait
was
a minute,
entered.
that's not in front of us. Don't tell us something we don't know about.
It's in the supplemental appendix.
Well, it's still not before us.
I don't understand. That's the order that was entered below.
Where is it?
It's at the supplemental appendix.
I have the one that's signed 10/1/2019.
Okay, and what's your concern about that one?
My concern is the confidentiality refers to something between Blue Cross Blue Shield and Biospine.
Right, the contract, right.
And where is the protection, for example, to how Biospine sets the charges for each CPT code? I can't think of anything more proprietary than that in this context.
You're going in and out there, but I think you said, where's the protection for what?
For how, I'm just looking at paragraph 5 of the order, how Biospine sets the charges for each CPT code that was used in this treatment. I can't think of anything more proprietary than how a medical provider assigns values to its CPT codes.
Did you say you can't think? Sorry, you're still going out. I think you said you can't think of anything more proprietary than that.
Well, you would agree that the methodology for setting charges for CPT codes is proprietary information, right?
Correct.
Okay.
Yes,
and my question to you is wait for me. My question to you is, where is the protection of that trade secret in this order, just as a for instance?
Okay, because the order does not say the contract between Blue Cross Blue Shield and Gulf Coast Spine is confidential. The order says Biospine can label anything it wants as confidential. And so I always, at all times, there's never been a moment when the defense argued, this is not trade secret, this shouldn't be confidential. The whole time I said, let's just admit this is all trade secrets. So step 1 of the trade secret protection is established. I admitted they're trade secrets. Step 3 is also established because there is an order, and that order says Biospine can label anything it wants as confidential. And I have to abide by that unless I go to a hearing and get the court to say it's not confidential. I never cared about those two because I never wanted to expose their trade secrets. I just wanted to get the information that 14 cases have said the defense is entitled to, not by virtue of any conditions preceding, but just by virtue of the fact that we have to pay the bill.
Mr. Pearl, I guess I'm confused now because you told me earlier that you were not looking for documents. And now in responding to Judge Libbert, you're saying that, no, you're looking at documents. So what relevance is a confidentiality designation on a document?
We asked for documents that are not part of this appeal. Gulf Coast Spine did not make the Blue Cross Blue Shield contract an issue in this appeal. So that's separate. So their argument is, in this appeal, you failed to protect my trade secrets that are going to be obtained only through the deposition testimony. Okay, so the contract's out. That has nothing to do with this appeal. So Gulf Coast Spine's argument is, I need protection. You didn't protect me for the testimony I'm about to give.
Well, I'm sorry. I'm going to have to ask you to back up. You said in your response to the last question that your client has to pay the bill, but that's not entirely true. The plaintiff in the personal injury action has to prove the reasonableness of the damages claim, and that's what your client is going to pay. So I'm still struggling with why Biospine's proprietary information is where this ends up as a matter of necessity for the defense proof.
Okay, so the answer to that question goes to the heart of the reasonable necessity argument, which I did argue below. Substantively, I did argue below. Procedurally, the court did not say reasonable necessity because of X, Y, and Z. But it is true that the defense would have to pay the whole bill. So you have to understand the way the right of a plaintiff to present an entire bill works with the collateral source rule when there is no health insurance reductions. Everything I said about health insurance in this case was just to show that there's no health insurance reductions. Everybody knows that, it's undisputed. $40,000 could or could not have been paid by Blue Cross Blue Shield, but it's not. So that's where we are. So what happens is when the plaintiff goes into court with their $100 ibuprofen pill, I use that example, okay? When they go in, even though everybody knows this $100 is ridiculous for one ibuprofen, the plaintiff is still allowed to say, here's my damages. That's Florida law, okay? And the jury, with no information by which to reduce it, let's say they award the $100.
And
Okay,
Mr.
when they're-
Let me interrupt you because you have reached your time, but go ahead and respond to that question.
Thank you. Thank you. So when there is insurance, the defense doesn't care that this, what Hassan called the discriminatorily high charge is presented to the jury, because we know that post-trial, we're going to get the set off, okay, for what Blue Cross Blue Shield adjusts. So they cut off $75. And now, even though the jury says plaintiff gets 100, the defense is only paying 25. But to answer your question, when there is no health insurance, a plaintiff presents the $100 ibuprofen, the jury awards the $100 ibuprofen, now we get no adjustment. There's no collateral source set off. So we're actually paying 100. We're paying 100. There's no place in the world where Gulf Coast Spine can get an unreasonably, what Hassan calls, a discriminatorily high charge bill paid other than through litigation when the patient doesn't have insurance. The plaintiffs and the provider then split this $75 extra that they can't get anywhere else.
Let me just ask this last question, since this is a very important topic, and I mean that seriously. You can ask Scott Cutler, Chief of Surgery, Neurosurgery at St. Joe's. He's aware of this procedure. He's aware of what it costs. You can ask him, is that a reasonable charge? No, it's not. Is it reasonable to use these amount of people in these techs? He'll say, no, it's not. What would you charge for it? He'd tell you, half, a third, whatever. You can get a billing expert to say, this is way overpriced. Plus, you can get the surgeon on and say, your bill here, outstanding bill is X. Do you intend to collect the entire amount from this plaintiff? Is he going to say yes or no? If he says no, then you're going to know it's negotiable. You're going to argue to the jury, you know what? We don't know what they have to pay. Therefore, it's unreasonable. So what I'm saying is what I'm getting at is you're talking about reasonable necessity to get trade secrets when there's other stuff and methods of discovery and inquiry as a trial lawyer that you can do to show the court you can't get it any other way because there's nobody else that can give you the substitute. Do you understand what I'm saying?
Yes. Can I answer the question?
Why is this based just on your arguments? Why is this in and of itself organically reasonably necessary for you? Why is this reasonably necessary for you when you have nothing else to show the necessity?
Okay. Again, this court is the court that denied that argument, that I'm stuck with what my expert would say or a comparison, because if you compare charges in a geographical area, which is category 1 Giacalone, what is the custom in the area. It was the Colomar case that explained this doesn't tell us reasonableness, because what if every provider in the area charges the same ridiculous $100 for the Advil? That is not a reasonable bill just because everybody's charging the same amount. And so this court rejected that argument about comparative market pricing and said you also get internal cost structure, and you also get what they recover, what they accept. The amount that this provider is willing to accept on this same CPT code is discoverable, and it is a reasonable necessity because there's no other way for me to tell the jury that the $100 ibuprofen is unreasonable. We need
but the amount BioSpine is willing to accept in settlement, full settlement of this medical bill and procedure is not a trade secret. You can just ask them.
Okay, well, then it's not a trade secret and we can just ask it.
No,
but I was
the
conceding.
amount they're willing to accept for Mrs. Walker's outstanding bill. What they will accept is not a trade secret.
Well, then it's discoverable, and that part wouldn't have to go back down, because that's all I'm asking is.
But you're seeking PIP charges and health insurance charges for every Tom, Dick, and Harry they ever treated.
No, Judge. the Lake Worth case says expressly, the defense is entitled to provider, show me 2 reimbursement fee schedules from any 2 healthcare providers you want and give that to the defense. This court, by the way, in LSI v.
All right,
McInnes,
we're done.
allowed-
Thank you. Go ahead.
Actually, Mr. Pro, I want to make sure that you've had the option to respond to the questions. We went way over the time. Anything at this time, really, really brief. All right, very good. Thank you, Mr. Pro. All right, Ms. Norse, you have 4 minutes for your rebuttal, ma'am, okay? And Mr. Pro, I'm gonna ask you to please mute your microphone, okay? All right, Ms. Norse, 4 minutes, ma'am.
Thank you, Your Honors. I just want to make three quick points. The first is that, you know, it's telling that the way to try to defend this order is to assert that it says things that it doesn't say. It doesn't say that confidentiality is guaranteed as to these 3 items. It's only limited to the first one. It shouldn't be subject to later debate. It doesn't say that the only thing that's compelled is deposition testimony. It doesn't say that there's any finding on necessity at all. And this was a proposed order that State Farm submitted. So I'm probably apologize for being skeptical that the wording of the order does not say now what is being argued, it says on appeal. The second thing is on the Giacalone case, I think the argument here basically proves the point that what is being done is an attempt to take limited cases in which a proper analysis was done, some in a case where the only issue was the reasonableness of the charge between a provider and a patient, and then expand it to become the rule. That the rule is you get this. He says, I've got 14 cases that say you are entitled to this information. None of those cases say you're entitled to it, not unless you prove necessity, not unless you prove why you need it in a way that makes you eligible to basically invade proprietary information. And I also would ask the court to look at the Colomar case and what happened in the Colomar case, because I think it's very telling. In her initial opinion, Judge Seitz out of the Southern District of Florida says some of this might be relevant, but in her subsequent opinion, when she grants summary judgment for the hospital, she says, you know what? They had the market rates, they could show that they were different, and they couldn't prove that there was a discrepancy that would show this charge was unreasonable. And that discrepancy in pricing in and of itself isn't proof of that. And that the overhead is so convoluted as to what gets included. So ultimately it comes down to market rate. It comes down to whether this was reasonable under the circumstances in accordance with the market, and that information is available. Just like for ibuprofen, I don't need to know how much the ingredients for a Tylenol pill costs. I can go and look at what it sells for on the market. And yes, if everybody is selling it for the same price, then that per fair market value definition is probably a reasonable price. And then third, I just, basically State Farm's conceded if you require express findings, the judge did not make them here. And the law is that express findings are required. Narrowly tailored discovery based on express findings of necessity. This is not a case where she just ordered 2 reimbursement rates. She didn't analyze it that way. And it does need to be reversed and quashed and sent back for the proper analysis. Thank you.
Very good. And thank you both. Really well argued on both sides. Thank you all. I think at this time, the court will be taking a 15-minute recess, and then we will be able to conclude with today's docket.